So, what happens when a single homeowner decides to take on the entire foreclosure machine? We're about to break down a really high stakes legal battle that kind of pulls back the curtain on how the system is designed for speed and what it takes for one person to try and grind all of those gears to a halt. You see, this story isn't just about a house, it's about the very rules of the game. Think about that for a second. This quote really tells you everything. The foreclosure system, for the most part, just runs on autopilot. With 96% of cases going completely uncontested, it's a process built like a conveyor belt, you know? It's designed for efficiency, not for a fight. But that other 4%, well, that's where you start to see the cracks in the armor. And that's exactly where our story begins. I mean, this is the classic David versus Goliath showdown, right? On one side, you have an individual fighting for his home. And on the other, you've got this corporate machine that treats taking someone's house as just another Tuesday. But the real fight here, it isn't just about property. It's about whether you can even get access to justice in the first place. This slide just lays the imbalance completely bare. On the left, you've got Jeremy Bass, a homeowner for 2 decades. After being turned away by, get this, over 100 law firms, all citing conflicts of interest, he was forced to represent himself, a situation the courts call per force pro se, which basically means he had no other choice. And on the right, a tangled web of LLCs with teams of seasoned lawyers. For one side, this is everything. For the other, it's just business. And this really brings us to the absolute heart of our entire explainer. When the whole legal framework is designed to just finalize property transfers as quickly and definitively as possible, how does one person even begin to challenge it? What does it actually take to slam the brakes on that machine and have someone listen to the real story? Okay, so to really understand how this fight was even possible, we have to know the rules of the game. In Idaho, the foreclosure playbook is basically written to favor 2 things: speed and finality. And it all hinges on one really powerful legal concept. And here it is, the bona fide purchaser. In simple terms, this is a good faith buyer. If you buy a foreclosed property and you have no reason to think there was any foul play, the law gives you this incredible protection. And why? Well, it kind of makes sense. Without this protection, who would ever risk buying at these auctions? The whole system would just grind to a halt. So that good faith status, it's not just a fancy term. It comes with this massive legal shield. A specific law in Idaho makes the sale final and conclusive as soon as that deed is handed over. This means any mistakes that happened before, like missed notices or procedural screw-ups, they're basically just forgiven and forgotten. It makes trying to challenge a sale after the fact, well, almost impossible. So you're probably wondering, if the law is that final, how in the world can you challenge it? Well, the homeowner's entire strategy hinged on attacking the one potential weakness in that whole legal shield, the good faith status of the buyer. The argument was simple. You can't be a good faith buyer if the auction itself was rigged from the very beginning. And this is the million-dollar question, isn't it? The law demands a fair, competitive public auction. But the evidence the homeowner brought forward suggested this whole thing was a complete sham. The explosive allegation? That the winner was pretty much decided before the auction even started. And the evidence? Wow, it was pretty damning. First, the buyer actually admitted to talking with a trustee before the auction. But here's the absolute kicker. They showed up with cashier's checks already printed out for the exact final purchase price. Now, in an auction that's supposed to be competitive, how is that even possible unless the fix was already in? This wasn't just some mistake. It pointed directly to bid rigging. And it's not just some wild theory. This expert opinion really underscores how serious these allegations are. A fair auction is simple. Everybody gets the same public information. The moment one bidder gets a secret heads up, the whole competitive process just collapses. It's not a level playing field anymore. So, facing a system that's designed to just finalize the sale and move on, the homeowner made this brilliant and totally unexpected move. He deployed a really sophisticated legal countermeasure that was designed to snarl the whole corporate machine in its own red tape. He signed a lease. And no, this wasn't about finding a roommate. It was a strategic masterstroke. By creating a legal tenant, he instantly dragged a whole new person into the fight, and with them, a whole new set of federal laws that are designed to protect tenants. Which should have been a simple eviction, just became a complex legal nightmare for the new owners. And get this, even the length of the lease, 2 years, was no accident. It was strategically calibrated. See, if it was too short, a court might just call it a sham. Too long, and it might be invalid. 2 years was the absolute sweet spot, long enough to create a massive procedural headache for the buyers while still looking like a totally legitimate deal. This strategy was just so smart because it was multi-layered. It was a 1-2 punch. Step 1, the lease, boom, you've got a tenant with federal rights. Step 2, a separate agreement made that same tenant the legal custodian of all the homeowner's personal property inside. All of a sudden, the new owners weren't facing a simple eviction anymore. They were trapped in this legal web, having to fight on 2 different fronts just to get control of their new property. Okay, and this is where the case takes a really critical turn. The fight stopped being about who was right or wrong about the auction. Instead, it became a battle over legal procedure, over timing, over rules. The process itself became the weapon. This timeline shows what some analysts called a temporal trap. Just a few days before the hearing, the plaintiffs drop a brief full of totally new arguments. Bass scrambles and files his response, but on game day, the judge refuses to even look at it, saying there is no provision for there to be a reply to a reply. Just like that. The results? The plaintiffs' last-minute arguments were left standing, completely unchallenged. And if you want to know what the strategy was, you don't even have to guess. The opposing counsel basically laid their cards right on the table. The plan was simple. Get Bass out of the house and get him out fast. Why? Because once he's not in possession anymore, they can argue his appeal is moot, a legal term for irrelevant. It's a cynical plan. Win the war by making sure the real battle over the rigged auction is never actually fought. And that's pretty much the bottom line here. The homeowner's core argument, all that evidence of a rigged auction, was never even really heard by the court. It was tossed aside on a technicality. The case wasn't decided on the facts or the evidence, but on a procedural trap. So let's just zoom out for a second. This one case, this one fight for a home in Idaho, it really puts the entire system on trial. It forces all of us to ask some really difficult questions about how justice actually works, especially when there's such a massive imbalance of power. And we can't forget what was really at stake here. This fight wasn't just over who gets to live in the house. It was over nearly $300,000 in home equity. And that's a super crucial detail, because Idaho law itself suggests that a financial loss this big could be the very thing that prevents the case from being dismissed as moot, a key argument that's part of the ongoing appeal. I mean, this quote is just stunning. This is an admission from an opposing lawyer. He's openly saying that Bass's arguments were logical and sound. The problem? He didn't package them in the specific jargon that lawyers use. This just reveals the core barrier for anyone trying to represent themselves. You can be 100% right on the facts, but you can still lose because you don't speak the secret language. And so this one case just leaves us with these huge systemic questions. Can the rules of the court, the ones that are meant to ensure fairness, actually be used as a weapon to deny it? How does our system protect somebody who can't find or can't afford a lawyer? And maybe most importantly, ultimately, this is the question we're all left with. Look, the foreclosure system is built to be efficient. We want it to resolve property ownership quickly. But in that relentless push for speed, where do we draw the line to protect the fundamental fairness that's guaranteed by due process? This one homeowner's fight in Idaho, it really forces all of us to stop and consider that question.